Good day. Thank you very much for listening to this week 11 JD workshop. And my name is Samuel Douglas. So just a brief overview of the cases to be discussed. The parties involved are James Hillard and Teams Australia Broadcasting Proprietary Limited. There's also another case with involving James and Southport University Hospital and Melissa Hillard, which is James's former wife, and Teams Australia Broadcasting Proprietary Limited. The causes of action available potentially will be duty of care and negligence. The CLA will be relevant, yes, in particular sections 2, 4 and 5 of the Civil Liability Act, Queensland, referred herein as the CLA. So, does TAB owe James a duty of care? Well, TAB would owe a duty of care to James for all foreseeable risks. That's as per the Australian Safeway store case. However, given the circumstances of the case involving another person being intoxicated and assaulting James, it would fall within the scope of TAB to prevent such criminal action from occurring from a third party. And that's consistent in the case of Modbury Triangle Shopping Centre. Section 46 of the Civil Liability Act Queensland specifically discusses the effect of intoxication on duty of care and the standard of care owed by an occupier. The fact that a person is or may be intoxicated does not increase or otherwise affect the standard of care owed to a person. And that's consistent in Section 46, subsection 1 in subsection C. So ultimately, James is owed a duty of care from TAB as per the last slide. So next question, part of the question. So can James bring a negligence actions claim for brain damage? Generally, a doctor owes a duty of care to patients as per Rogers and Whitaker. A medical practitioner is expected to exercise reasonable care in an examination, diagnosis, treatment, and provision of information of and for the patient. Section 9, subsection 1 of the CLA provides a list of general principles as to when a person does not breach a duty to take precautions. This includes things like risk of foreseeability, significance of risk, and whether a reasonable person would have taken precautions. A relevant factor into this case is the fact that 2/3 of our doctors would have normally operated on James immediately, given the seriousness of the injury and that he potentially would suffer major brain damage in that situation. It appears on the elements of subsection 9, subsection 1 of the CLA have not been fulfilled to exclude TAB of liability of injury caused to James, but however, there's some other factors to consider in the next slide. Section 9, subsection 2 of the CLA provides for other considerations, including the probability of the harm would occur if care were not taken, the likely seriousness of the harm, the burden of taking precautions to avoid the risk of harm, and the social utility of the activity that creates the risk of harm. It appears the elements in Section 9, subsection 1 and 2 of the CLA have not been fulfilled to exclude TAB of the necessity to provide a duty of care to James. It's also necessary to consider factual causation and scope, as per Section 11, subsection 1, A and B of the CLA to establish liability, presuming duty and breach has occurred. Section 22, subsection 1 of the CLA states the professional does not breach its duty arising from a provision of professional service if it is established that a professional acted in a way that was widely accepted by peer opinion and by a significant number of respected practitioners in the field in a competent professional practice. So the fact that they did the professional sort of deviated and delayed the operation, that was just their own professional opinion. So that's probably going to work against James making a negligent action based on that part of the of this section. In addition, Section 22, subsection 2 states that peer professional opinion cannot be relied upon if the court considered it irrational or contrary to written law. So, given the challenges surrounding Section 22, it's actually unlikely that James will be able to establish a causal link that TAB is liable. So, next part of the question, does TAB owe Melissa a duty of care? The Plaintiff needs to have suffered a recognised psychiatric illness. Damages are recoverable only for injuries constituted by a reasonable psychiatric condition and not from emotional distress, alarm, fear, anxiety, annoyance, or upset, as per the Tame case in New South Wales of 2002. The case lists out factors relevant to consider. For example, normalcy of reaction by the plaintiff. Was there a sudden shock? Was the plaintiff at the scene or immediately there at the aftermath? Was the plaintiff perceive the events with their own senses? And was there a pre-existing relation between the plaintiff and the defendant? So the circumstance of the case essentially was that there was a sudden shock with the former wife. Whether it's normal reaction, possibly. Melissa sort of was there, shortly after the incident, to be with James, and yes, there was a pre-existing relationship, considering that they were parents to their children. So the fact that they were divorced or separated was inconsequential in that sense. So, considering the circumstances between the parties, there's a high likely chance that duty of care will be owed by TAB to Melissa. Okay, moving on to question 2, which will involve advising Mindy if she can bring a successful negligence action against the council, and secondly, advising Marilyn if she can receive compensation and/or damages for her permanent nerve damage. So, does the GCC or the Gold Coast City Council owe a duty of care to Mindy? Firstly, Section 34 of the CLA defines a public and other authority. So the Gold Coast City Council would be, according to the definition as per that section, would be considered to be a public authority. So to establish a duty of care in this instance, it's important to consider whether the defendant could have reasonably foreseen that their acts and omissions could cause damage of the general kind suffered by the plaintiff, as per the case in Chapman in Hearson. Section 35 of the CLA provides principles that apply to proceeding in deciding whether a public or other authority has a duty or breached a duty. Section 37 also stipulates that a public authority is not liable for legal proceedings, in certain circumstances. For instance, unless they have had actual knowledge of such an incident, they wouldn't be liable. And that's as per subsection 2 of the Act. The GCC did not possess such knowledge of any issues with the potholes on the road. This ultimately means the GCC would not owe a duty of care to Mindy, as actual knowledge must be found in the mind of an officer within the council who has delegated authority to carry out the repair, consistent with North Sydney Council and Roman. So the last part of this question is advising Marilyn if she can receive compensation and/or damages for her permanent nerve damage. So an employer owes a duty of care to employees to take reasonable care in the circumstances to avoid foreseeable injury to an employee, and this is consistent with the Zach Tyrico and Edith Cowan University case of 2005. The employer is under a duty of care to ensure there's no defects in the plant and equipment, as per the Bellamy Coal & Co. Limited and Murray case in 1909. So the fact that there was some problems with the editing machine, is a responsibility of the employer to make sure that there is no defects. So the possible damages that potentially could be awarded in this situation is stipulated in Section 140 of the Civil Liability Act, or No Fault Scheme. This could be through weekly payments and/or injury if the permanent. This could be through weekly payments, and where the injury is permanent, could be through a lump sum. The onus of proof will fall on Marilyn to prove liability as per Section 12 of the CLA. Something to consider in this case. There also is a possible avenue for damages awarded depending on the degree of permanent injury through Section 179 of the CLA. This would not be through the fault scheme. Section 305H, subsection 1, talks about contributory negligence of the so that is in the CLA, which could be relevant in this case, given that Marilyn did not use gloves which were given to her by her employer. So that could be a potential issue that could throw out this case. However, I think that a plausible defense could be for Marilyn is that it affected her ability to perform her job, and it was required for her to take off the gloves that she was given, considering that she had serious time pressures. So I believe that actually Marilyn has reasonable prospects of success receiving compensation and damages in this circumstance. Thank you very much for listening to my presentation, and I look forward to seeing you next time. Bye.